Hi, I'm Emily Hicks, and I'm the attorney here at Emily Hicks Law. And I wanted to talk today a little bit about trust. People often think that this is something that's reserved just for the ultra rich or the wealthy, but I'm here to tell you that that's not the case, because the majority of my clients like to use revocable trust in their estate planning, and I'm going to tell you why. I'm also going to talk a little bit about the difference between what a revocable trust is and what an irrevocable trust is. So generally speaking, I like for people to think of a revocable trust kind of like a legal container that is going to hold your assets for you. And the reason that we want to do that is because when someone passes away and they have an asset that's in their personal name, then there's really no way for that person to then pass title to whoever they want it to go to. Meaning, if I have a house and it's in Emily Hicks's name, and I pass away, then there's no way for me to now sign a deed to that property, right? It has to go through the court process so that a judge can legally decide who is the actual new title holder to that. So what we want to do, with revocable trust is avoid that process. We don't want to have to probate anything. We don't want to have to go through the court process. We want it to be done privately within the family. So we create a revocable trust, and that is essentially a vehicle for title to your property. It's an extremely flexible, great tool. There's so many benefits that it would be a 10-minute long, discussion about it, but it's really the core of what most estate plans look like now. Now, another question that I get is, well, do I need a revocable or an irrevocable trust? Because I want to protect my assets and I want, everything to be, one thing that kind of buzz, phrase that I hear a lot is, I want to control everything but own nothing. So, and that's I think a Rockefeller thing. But one thing I want you to understand about irrevocable trusts is that they're really done in certain instances. The evolution of asset protection that has come about, within the legal field has really stemmed from bankruptcy. So if you are someone that is in a situation where you're anticipating a bankruptcy, or maybe you are engaged in a very high risk profession, then that's something that we can think about doing, because an irrevocable trust is something that cannot be changed after it's set up. Meaning, you're going to now put some assets into a trust that you can no longer have any control over, any access to, and that can never be amended. It can never be changed without going through an extensive court intervention and court process. So it's a very extreme way of planning, and it's not something that 99% of the people are really looking to do. Like I said, it's really in certain instances where people are anticipating bankruptcy, and are looking for asset protection in that way. Or perhaps there are some instances where people are looking, for Medicaid asset protection trusts and things like that, but that's a little bit of a different animal. So the majority of people that I work with are looking to establish a revocable living trust or living trust. It's the same thing because that's what's going to help their family avoid probate. That's what's going to hold title to property or become a beneficiary of certain things like life insurance or retirement accounts, depending on what your plan looks like. And that's what we generally are looking to set up. If you're looking to get your estate plan set up, please give us a call. We have a free initial call that you can book right on the website, emilyhickslaw.com.